Hello, everyone, and welcome back to our session 2. Now we will be having the session on navigating the autism diagnosis process and transition from EI. We have Sylvia Call joining us today and Aimee Gilman. I'm going to go over their bios and then they will start their session. Sylvia spent the first decade of her professional career working as a high school English teacher and an adjunct professor in the field of literature. She moved into the field of autism therapy in 2018 after her son was diagnosed with autism spectrum disorder. Sylvia currently serves as the Autism Services Coordinator for both Fayette and Highland County Boards of DD. She provides direct therapy to families on her early intervention caseload, and she also runs both counties' ADEP program. Aimee Gilman is entering her 40th year in the practice of law, focusing exclusively on the representation of children and adults with special needs. She's a principal in the law firm of Agins and Gilman, and they practice all over the state of Ohio. She is from Cleveland and has a 35-year-old son with autism. I will now turn it over to Aimee and Sylvia.
Hello, thanks for joining us. All right, let me get my PowerPoint shared so that way you guys can kind of see what Aimee and I are talking about. All right. Okay, is that showing up for everybody?
Yes, we can see it.
Okay, good deal. Okay, when I've got it shared, everything else is minimized, so I couldn't see, but I wanted to make sure it's up there. So I joined the Fayette County Board of DD and Highland County Board of DD's early intervention teams a little over a year ago in the role of a developmental specialist, but also in the role of the Autism Services Coordinator. And the primary piece of that role is running both counties' ADEP programs. So if you're not familiar with what ADEP is or what that means, I'll share a little bit about what that process looks like, how it's been beneficial for our communities, and a little bit about how we kind of roll that into the early intervention world. Like Erica shared, my son has a diagnosis of autism spectrum disorder. He was actually in the early intervention program for Fayette County. So a lot of the team members that I have for Fayette County were also working with my son years ago when he was in the world of early intervention. And clearly that made a huge impact on our lives as a family and impacted me professionally because it was such a cool concept to empower families and to encourage them to kind of take the lead in providing some of these therapies under the direction of a primary service provider. So it was just really impactful for not only my family and my son, but for me too. I was like, oh, I want to do that too. So here I am doing just that. But it's been a great transition for me. I miss my high school English days every now and then, but I really do enjoy my work in the world of autism. So for those of you who may not be familiar with ADEP, that stands for Autism Diagnosis Education Project. It's something that's available to all 88 Ohio counties, and it provides counties the ability to do autism evaluations as well as diagnosis at the local level, which is huge. When my son went through the evaluation process, the wait list was a little bit less back then. We waited for the full process about 8 months from start to finish, which is fabulous compared to kind of where we are now because of the post-COVID numbers. But this allows us to do that same level of autism evaluation and then meeting with a licensed doctor or a nurse practitioner who's able to do that and provide the family all of that at the local level. They're not having to travel for an hour or two with their child to multiple meetings over the span of 2 years at this point. So it's been huge for our community, and it's been wildly successful, like far more popular than we could have ever dreamed. At the start of my tenure with Fayette County, my director and I kind of sat down and pieced out what my role would look like and how it would kind of work. And at that point, we kind of thought we'll have a lot of referrals early on for this autism evaluation, and then it'll kind of dwindle. Well, the dwindling still hasn't happened. We're about 1.5 years out. And I think it's fabulous. I think it's a great opportunity to serve these families and to provide this quality service at the local level. So we do partner with a local physician. She owns a pediatrics office. And Dr. Fitton does provide like the final diagnosis for the children who go through our program. I've had a few other counties from around ours who are aware of what we're doing reach out to me and ask, what all is involved? What training do you do? What does it really look like logistically? What are the responsibilities of your medical partner? And I won't get into all of that today because it's not as complicated as I initially feared it would be. It's really turned into kind of a smooth, seamless process for our counties. But I would be happy to share if there are any early intervention teams in the state of Ohio listening who would be interested in just kind of our process. Maggie Gons from Ocala oversees our ADEP program and the other ADEP programs in the state, and she provides a ton of wonderful resources as well. So she's always a great point of contact as well. Here, I think it's popped us out of our little thing. Sorry, I am not the most savvy with technology, so I'm trying. So families get a lot of information front loaded to them about the ADEP program. I didn't want to bombard the slides with all of that information. I wanted to be able to leave plenty of space for Aimee to share her portion, as well as leave room for some questions at the end. But I did want to give a nod to our little ADEP team, my support person Chicken in there in the picture with me. So Dr. Fitton is our medical partner, and families get a copy of this form along with a lot of the wonderful information that Maggie provided us from Ocala that just kind of gives an overview of what ADEP means, what tests are provided, what it looks like at the local level, and the diagnostic process. So families get a copy of this, and I just wanted to give a nod to Dr. Fitton because without her, we really could not run this ship the way we do. And then I wanted to celebrate some of my little ADEP people with the permission of their families. So ADEP is under the umbrella of early intervention, but it's separate from services. So this little guy, his name is Ren, was on my caseload as a DS, but he was also a little one who went through the early intervention program as part of the ADEP piece. So I worked with him in both capacities, with him and his family. And he's graduated from our program now, and he attends our preschool. But Mom said, yes, absolutely, share Ren. So we love to celebrate Ren. But Mom had a child, Ren's older brother, who also has a diagnosis of autism. And older brother went through the traditional nationwide children's process. And it took, she said, about 2 years to get the full process completed and to receive the diagnosis. So she was super thrilled that she could go kind of through the same process at the local level. And Ren had a diagnosis from a medical doctor within 2 months of starting that process. So we want to celebrate Ren. And then another little guy that we always love to celebrate. He was also on my DS caseload, but he was also an ADEP kiddo. So this is Carter. Carter's mom was fun because she initially was very, very hesitant about the process, and autism was a scary word, as it is for a lot of families. So it's nice to be able to share my own experience and to talk about where I come from in the world of autism and how, autism personally impacts me and my family with our son having a diagnosis. So I think that that helps significantly kind of ease people's minds, and it becomes less of a scary word. So we want to celebrate Carter. He was a lot of fun. So just kind of in a nutshell, when a child receives a diagnosis of autism from Dr. Fitton, a few things happen. So the child's family receives a collection of resources, and that's a collaboration of papers that they can read, primarily publications from Ocali. It includes some books on the topic of autism and how it relates to little ones. And they're books that I found personally helpful when my son was diagnosed. And then they get some cool things for the kiddos. They get kind of a fidget blanket and some chewy tubes and just different sensory pieces. Just all of the things that I would have liked to have when my child was diagnosed, and didn't know that they even existed really at that point. They can receive prescriptions from Dr. Fitton if they're interested in the opportunity for outpatient therapies. And then, of course, they still continue in early intervention therapies as well. And it's nice because it's a team approach. So we're able to provide that information to the rest of the team in real time. And if there are any adjustments that need to be made to that therapeutic approach for that child, we can then reflect that in the IFSP. If the child is not currently a patient of Dr. Fitton's, then she provides a copy of all of the diagnostic information to that child's pediatrician or medical provider. And then with family consent, the local school district is provided with copies of the ADEP report and all of the diagnostic information at the time of transition for that kiddo, so that their needs can best be met. And that part of the process is where our team met Aimee Gilman, and we are very grateful that Aimee lent her expertise to one of the families that we served, and just provided some counsel for not only that family, but just some good information for us. So I am thrilled to turn it over to Aimee so she can share some of her expertise in the field.
Hello, everyone. As Erica told you, I am an attorney. I've been an attorney for almost 40 years, and I also have a child with autism who is now 35 years old. So I've been involved in this process at a time when the incidence of autism was 1 in 10,000. My son was diagnosed when he was 18 months old in 1989. So, I have been on various sides of this table, but I am unapologetic. I am an attorney who represents parents and people with disabilities. So when you hear from me, you're going to hear that side of the story, because that's what I do. I don't represent school districts. And again, Sylvia's explanation about how we came to know each other is because I got involved with a case involving one of her kiddos. So the issues, I am not going to talk a lot about the statutory basis for the transition from Part C to Part B. That's for another day. But for those of you, and I wasn't involved in the first part of this presentation, but of course Part C refers to that portion of the IDEA that provides the laws governing the education of individuals, the services for individuals ages 0 to 3, and Part B of the IDEA is that portion that governs the education of school-age children from ages 3 to 21. Now, obviously, in addition to the federal statute, we have the state of Ohio has its own laws and operating standards that govern both early intervention services as well as school age services. And the early intervention services you can find in the Ohio Administrative Code at 5123. Part B services, again, which begin after age 3, are found in 3301-51 and then onward. So you can go ahead, Sylvia. There you go. I do apologize about the pictures. I do want you to know that I normally have somebody else do my PowerPoint presentations, but I was on vacation And when I came back, there wasn't time to have somebody do my PowerPoint. And I am not very good at doing, I can't do where the letters float off the page or anything like that. So I uploaded some pictures to give you a little bit more interest. And yes, if you're wondering if that is a dog sleeping on the bed over here, yes, that is. There's also a dog under the table. This is a hairy coo or a Highland cattle picture that I took. So I do apologize, but I just wanted to have some interest as opposed to blank white paper. So there you go. So, Sylvia's explanation about the early intervention services that are provided by the DD are absolutely critical. There is no way to overstate how critical it is for a child to receive those services and the diagnosis and as early as possible. What I'm here to talk about is what the school district's responsibility is as part of the transition from a child who's receiving early intervention services to a child who is eligible for Part B services. The school district of the child's residence is required to participate in the transition planning for a child. And that prior to the child's 3rd birthday, and the law provides that the school district is required to have an IEP in place by the child's 3rd birthday. Now, there are exceptions, including the fact that if a referral isn't made in time for the school district to complete the evaluation, then they are not required to have an IEP in place by the time of the child's 3rd birthday. But, with all of these statutes and all of these regulations and the ADEP program, you might be asking yourself, what could possibly go wrong, right? I mean, we have all these things in place. And if nothing ever went wrong, then I wouldn't be in business. Unfortunately, the involvement that I had with Sylvia and the Fayette County DD is because things do go wrong. One of which is the school district is not permitted to simply turn its face away from a child who is obviously struggling so that the child doesn't need to have services in place. The purpose of the transition process from Part C to Part B is to enable the child to have a seamless movement from the early intervention services to the school age services, so that there is no break in the services that are necessary in order for this child to optimize what their functioning. Again, because you can't overstate the importance of early intervention. And that's the reason why we have this transition process, is so that we have this seamless movement. And the school district cannot refuse to be involved in this process, because what ends up happening, and what happened in the situation that I was involved in with Sylvia, was that there was a break and the child wasn't receiving any services for a period of time. So the first thing that the district has to do is make a determination about whether or not the child needs to be evaluated as a child with a disability. Understanding that in order for a school district to trigger the right to evaluation there has to be a referral. The fact that there is an ADEP comprehensive evaluation all by itself isn't enough. There has to be a referral, and that referral can be made by anybody. It can be made by the parent, by a teacher, by an early intervention provider, by a related service provider, by somebody who's completely unrelated to either one of those things. And at that point, the school district has to determine whether or not the child is suspected of having a disability. So the question is, what happens if the school district refuses to evaluate the child? Now, you might be saying to yourself, why on earth would a school district refuse to evaluate a child who had a comprehensive evaluation by an early intervention service provider and a medical doctor who diagnosed the child as having autism? So let's get into that a little bit. Sylvia, there you go. So we have a 2-year-old child assessed by the early intervention team, found to have moderate to severe autism and a language delay. This information is communicated to the LEA, which is the IDEA term for the school district of residence. The school district observes the child and determines that the child is not suspected of having a disability and refuses to evaluate. Now, let's talk for a moment about the initial basis for the school. Oh, this is Rosie. This is the dog that's sleeping on the bed. She's a senior rescue. She's in her active mode. And so the school district's initial position was, this is a medical diagnosis. We don't have to accept a medical diagnosis. And I have heard this time and time again. There's a difference between a medical diagnosis and educational autism. I mean, I'm not going to even, the notion that a medical diagnosis of autism doesn't trigger the need for a school district to suspect that the child has a disability is beyond. I mean, I won't say stupid, but it's stupid. Okay, there it is. And so you have this kid who's got this comprehensive evaluation and a diagnosis by a medical doctor. And the school district does three observations, okay? The first observation is done by the school district's parent mentor. So for those of you who aren't familiar, the Parent Mentor Project is run by Ohio State University. It used to be run by the Ohio Coalition, but now it's Ohio State. And the parent mentors, in this particular case, most of the parent mentors are parents of children with disabilities. But most of you who are parents of children with disabilities, including myself, would realize that that doesn't give you the credentials necessary to determine whether a child is suspected of having a disability for purposes of the IDEA. And so, so this gal went in there together with one of the school district administrators and observed this kid and said, no, she's doing okay. Worse than that, the school district sent in their speech and language pathologist. And the speech and language pathologist did an observation, and she wrote a report which did not include any information about when she did the observation, the date, the time, how long she was there, whether or not she had reviewed any of the records that had been provided by the early intervention team, or any other information that would have been sufficient to make this of any value whatsoever. And on the basis of those three observations, the school district declined to evaluate this child. And again, and I see people asking questions, the issue is not whether or not the child is eligible as a child with a disability. Right now, we're talking about whether or not the child is suspected of having a disability that would require the district to evaluate. When you have a comprehensive evaluation that's done by a doctor and an early intervention team that says the child has moderate to severe autism and a language delay, there is no legitimate legal basis for refusing to do an evaluation. That is this one's opinion, and my opinion is the only one that matters. And so there you go. That is, in my opinion, that is just ridiculous. And yes, the definition under IDEA of what qualifies an individual under the category of autism is something that has to be determined by the school district. But the notion that that child is not suspected of having a disability is frankly ridiculous. And so I mean, you can talk to me about medical diagnosis, and yes, the medical diagnosis is not a substitute for the evaluation process. No one's saying that it is, but the school district had ample information from which they needed to determine that this kid warranted an evaluation. So what can you do when that happens? Well, you can file a complaint with the Ohio Department of Education. You can file a due process complaint. You can request mediation without filing a complaint. And I would urge anybody who's in this situation to consider using an advocate. The Ohio Coalition for the Education of Children with Disabilities has advocates that cover, they are the statewide Parent Training Information Center, and they cover the state of Ohio, and their services are without cost because they're federally funded. So And so when you have a kid who's receiving intensive EI services, unless that child is remediated by the age of 3, and there are those who are, they need to be evaluated to see if they're eligible for school age services. So, so can we go to the next one? So that's Mabel and Rosie in their matching winter coats. So Mabel is the pug, and they're both senior rescues. Mabel is the one who's under the table here. They will not speak a word of this to anybody, I guarantee it. So again, when you are making a referral to a school district, make sure that the referral is in writing. Districts do have 60 days from the date of parent consent to complete the evaluation. I do want to stop for a moment to talk about the parent consent. When a referral is made for a child who is suspected of having a disability, the school district doesn't have infinite amount of time to obtain the parent's consent, because the 60 days doesn't begin to run until the parent signs consent. And so what you can do is you can send in a consent form that you have downloaded from the Ohio Department of Education's website. And because a lot of times they just won't have the parent sign consent, which delays the process. And so you need to make sure that if you have a referral, that the parent has signed the consent form. So, so if the district agrees to mediation, you should consider asking an attorney to review the proposed agreement, and I'll give you an example. In the particular case in which I got involved with Sylvia, the district agreed to mediate this situation. At the mediation, the district offered a settlement agreement in which it agreed to evaluate the child in exchange for the parent's release of all of their claims. Now, wisely, this parent at the time did not have an attorney, declined to sign that. You do not have to sign a release in order to get the district to do what it's legally obligated to do in the first place. The basis for their assertion that they did not need to evaluate this child was they didn't have any data. And of course, what a convenient argument that is for a school district. So they don't evaluate, which would enable them to get the data. And of course, in this case, the notion that they didn't have data was absolutely ludicrous, because they had a comprehensive evaluation that was done by the EI team and Dr. Fitton. And so, so you have this like circular argument that they don't have any data, but they're not going to evaluate, which would give them the data to enable them to determine whether or not this person is eligible as a child with a disability. And so, but I mean, again, if you are going to mediate over this, the school district has an obligation to evaluate that student, and they can't use the fact that they don't have data, particularly in this situation where they had ample information from which to determine that the child was suspected of having a disability. Furthermore, the school district is free to use that information in the course of its evaluation in determining whether or not the child is actually eligible. Retaliation. At the time that this mediation occurred, the school district had its lawyer present at the mediation. There was an individual who was there to advocate on behalf of this kiddo, and that person was threatened with, does your boss know that you're here? And actually proceeded to call the superintendent of the DD and complain about the fact that this lady was present advocating for this 2-year-old, or at that time 3-year-old, disabled child. As I said at the time, it's really unfortunate that the superintendent of that DD elected not to fire her, because that would have been such a great federal lawsuit and we could have all retired. Unfortunately, she still has her job, and so we are not retired. But you are not permitted to retaliate against somebody for advocating on behalf of a disabled student. And that zone of protection includes not just the parent, it includes anybody who is within the zone of that child's advocacy, who is there and being retaliated against because of their advocacy on behalf of the kid. The other thing I do want to mention that's very important is that the school district's agreement to evaluate this kid was really a big nothing, because the evaluation, I mean, what are the chances in this situation that the school district was actually going to find that the kid was eligible? So they could have gone ahead, she could have signed away all her rights. The school district could have gone ahead and evaluated the kid and said, well, she's not eligible for services. And at that point, the parent is screwed, because they have now waived all of their rights and they have nothing. They have an evaluation. I mean, they can go ahead and challenge that. They can get an independent educational evaluation, which is there on the slide, if you don't agree with the results of the evaluation. But in terms of mediation and signing away your rights, then you need to be very, very careful, because again, the fact that they have a right, they have an obligation to evaluate without the parents releasing all of the claims. If they do an evaluation and they find that the child isn't eligible, you do have the right to request an independent evaluation and the school district has to consider the results of that. And then, of course, if they do find the child eligible, you need to make sure that the services on the child's IEP are sufficient to enable the child to benefit from those services. And I'm not going to get into all of that, only to say that children who are children at that preschool age, more is better. When you hear a school district say, well, we're only going to give the kid 30 minutes a week of speech therapy for a kid with a significant language delay, 30 minutes every other week, because that's all we do. That's not how services are determined. Services are determined by what is necessary to enable the child to make meaningful educational progress. For a child, and particularly this kid, because the little one that we were dealing with has immense potential, really potential to be in a gen ed classroom all day long. But the idea that a kid like that doesn't need more than 30 minutes every other week, because that's all the school district provides, that's not how services are determined. Services are determined based on the child's needs and what's necessary in order for the child to receive a free, appropriate public education. Next one. Let's talk about what happens in the event that the school district fails to comply with its obligation in a timely fashion. So what happened in this particular case was the school district declined to evaluate, and they were absolutely dug in. This kid actually had another evaluation by a speech and language pathologist to determine her eligibility for Social Security disability. That speech and language pathologist made a referral for school-age services to the special education director of this school district and said this kid has a significant expressive receptive language delay. And the special education director of the school district said to her on the phone, there, under no circumstances are we going to evaluate this child, period. So I get the phone call. The case is already in due process. And I have a conversation with the attorney who's representing the school district, bless his heart, who says to me on the phone, well, you have to understand, Aimee, that this isn't just about this kid. If they evaluate this kid, then, you know, there's a lot of other ones waiting in line. And I'm thinking to myself, why on earth would anybody say that to their opposing counsel? And I won't say that it was stupid, but oh my gosh, are you kidding me? And so I said, can you repeat that again into the flower? Because I'm not sure I heard that right. And so, you know, I amended the due process request. And you have to understand that at this point in time, this kid has now been without any services for several months. This kid is now 3 years old and has not had any services. And I am going to tell you here and now that no matter how many lawyers you have, no matter how many lawsuits you file, no matter how much service you obtain later on, there is no way to make up to a child with a disability for the loss of services in real time. And I am going to say that again. The loss of services in real time to a child like this is not, you can never make it up. It doesn't make any difference how many days a week you provide the child with speech therapy or other kinds of therapies and services. Those days are lost forever. And for a child with autism who is 2 or 3 years old, every single day is a precious jewel. And when you lose one of those days, you lose, I mean, this is this child's life. And I mean, I don't want to get maudlin about it, but I've been there and done that. My son was in speech therapy at 18 months, 5 days a week for an hour every single day for almost 9 years. And so the notion that they can take their time and that somehow if you get a lawyer, it's going to make it all better, it is not going to make it all better. It's going to make it better. But I mean, in my business, I have to tell parents all the time that you have to understand that whatever I can obtain for you is not going to make up to your child for what your child has lost. And so I can't stress to you enough the fact that if you find yourself, whether you are a related service provider, an early intervention provider, a teacher, a parent, if you see that they are going down this path where they're not going to evaluate or they are not going to provide services, and I'm talking about not just the refusal to evaluate, which we see more and more of, but I'm talking about the refusal to find the child eligible at all. You can't sit on your hands. You have to take some action. The other thing I do want to tell you is that the lawyer for the school district argued with me, always a foolish thing to do, but he did argue with me about whether or not the hearing officer in this case had the authority to find that the child was eligible when the school district had not evaluated. And I said, we are certainly going to ask the hearing officer to find that the child was eligible. And he said, well, how are you going to do that? We haven't evaluated her. I said, well, we call that the presentation of evidence. We're going to put on evidence from the child's early intervention team that this child is eligible under the educational category of autism as a child with a disability. It's not just school district personnel who can testify about whether or not a child meets the definition under the IDEA as a child with a disability under that category or any other category. Because this discussion doesn't just apply to children with autism. This discussion applies across the board to children with disabilities, whatever category they may fall under. And again, there are 13 categories of eligibility under the IDEA. And so I'm not really sure where he was going with this because, in my opinion, if he was intending to argue that the hearing officer didn't have jurisdiction or authority to make a finding that the child was eligible, I think that's mistaken. We actually had a case that went to trial, and that decision is available on our website involving a school district that evaluated the kid but declined to find eligibility. And in that case, the hearing officer found that the child should have been found eligible and ordered the school district to find the child eligible for services and to provide compensatory education. So let's talk for a moment about compensatory education. Compensatory education is generally provided by a hearing officer. It's very, very unusual for the Department of Education in Ohio to order compensatory education. It's not unheard of. If it's something that is like really clear, I'm going to move out of the sun here. If it's really clear that the speech therapist was, they didn't have a speech therapist and the child had speech therapy on their IEP and no services were provided, they probably would order the school district to make up those services on an hour-for-hour basis. Compensatory education that's ordered by a hearing officer is different. The compensatory education that's ordered by a hearing officer in a due process case are whatever services are necessary in order to restore the child to where they would have been, but for the denial of a free, appropriate public education. Now, as I said before, there's no way to make up to that literally in real time what the child has lost. And so in this particular case, this child was not awarded, we actually never went to a hearing, the case settled, the compensatory services for the period of time that she lost. And she was placed into a preschool program, and the compensatory services in that particular case were provided by an outside related service provider that the school district has to pay for. Compensatory services can be presented in a variety of contexts. We have compensatory services for children who need reading remediation, math remediation, speech therapy, occupational therapy, physical therapy, cognitive behavior therapy, counseling. I mean, compensatory services can be in many different forms. They can be provided by individuals within the school district, or they can be provided by third-party providers. Generally speaking, and I had told the school district's attorney that the speech and language pathologist that did that report that was really of no value whatsoever because she didn't have any information in it, was not going to be the person to provide compensatory education to this little girl. And so, so you do have some say in who is going to provide the service, particularly for a child with autism who may have a variety of presenting challenges, including behavioral challenges and so forth. I mean, a child with autism who does have behavior challenges needs to have individuals with behavioral backgrounds who are going to be providing the services. Behavioral services can be part of compensatory education. So for kids who have significant maladaptive behaviors, those behavior services can be ordered by a hearing officer, or you can, in most of these cases, settlement, most of them don't go to hearing, but you can go ahead and agree in a settlement agreement about who is going to provide the compensatory education. And generally speaking, when you are being provided with the compensatory services, the school district is going to ask you to release the claims that you had up through the date of the agreement. You would still maintain all of your rights to receive a free, appropriate public education, going beyond that. So, I think, the fact of the matter is that if this family had not challenged their right to have their child evaluated, then this kid would still be without any services, because the school district in this particular case was certainly not in any hurry. They had already said they weren't going to evaluate her. And so, so I see that there's a lot of questions. I don't know if, again, we had such a limited time here, and I just want to make sure, and I told Erica before we started that I don't like to leave any kind of situation where people do not have their questions answered. I do want you to know, and that my email address is here on these materials. And so if you have a question, particularly if your question is about your individual situation, you should contact me either by calling the office or emailing me. We have a very user-friendly office, mostly because we no longer have a secretary, so it's just me and Carrie. And so if you have questions about a particular situation that may not be as suitable to be answered right now, you can always reach me by email or phone call. And I do get phone calls from teachers, related service providers. I've even had phone calls from superintendents. And so again, we're a pretty user-friendly office. So Erica, do we have questions that you think
Yes, it looks as though we have a very engaged chat. Some are just some comments that I'll run through and then some questions. And like Aimee said, if it's a specific case, feel free to email her and she'll be able to address that specific situation. The first question is, can this be required training for Part B? I think
And
that
so
this,
that are you talking? I'm not sure what the person is talking about. Can what be? Oh, you mean this talk?
I would say this topic today. I think that could be a good suggestion.
Right. So, if you're talking about whether or not this is a required training for school districts, the answer is no. The hope, though, is that all the school districts in the state of Ohio either have in-house attorneys like the large school districts like Cleveland and Columbus, or they have outside counsel that are on retainer. And so the hope is that their outside counsel is advising them about what their legal obligations are. Again, unfortunately, in the situation in which we found ourselves, my personal opinion is that, the school districts, if the school district's attorney was telling the school district that it was okay for them to refuse to evaluate, I think that was unfortunate.
Yes, and there are several comments in here stating that they often see districts refuse to evaluate.
I will say too that the refusal to evaluate is especially unfortunate because aside from let's set aside the harm that it's doing to the disabled child. Okay, it's so silly. It doesn't cost anything to have a psychologist and a teacher and a speech therapist, conduct an evaluation of a disabled child. But it's very expensive when the school district has to bring its lawyer in and pay its lawyer by the hour and then get sued by somebody else. And if they lose, they have to pay my fees. And so, in the case that's on our website, the Maplewood case, they lost the case. The amount, the school district, a tiny little school district, the amount of money they spent on that case was like obscene.
The next question is, can a district refuse to evaluate a Spanish-speaking child because they claim that they are unable to determine if the cause of delay is a lack of English proficiency?
No. Does that answer your question?
It does. How does the new autism education plan under the scholarship affect services in a public school?
So, it's kind of interesting, and I intended to bring that up, but the issue of the sort of medical diagnosis versus the educational category is now being blurred because the autism scholarship, the new law under the autism scholarship provides that the category of eligibility is no longer determinative of whether or not a child is eligible for the autism scholarship. If the child has a diagnosis of autism by a medical doctor or a clinical psychologist, the child is eligible for the autism scholarship, regardless of what category of eligibility the child is found to be eligible under, and that law just went into effect. So that is further blurring the lines between the so-called medical diagnosis and the educational category.
The next question is, what about a child who doesn't have a diagnosis? However, the early intervention and family suspect a disability, and yet following one 30 to 60-minute observation and interview, the school district refuses.
So, obviously, if you believe that the child has a disability, it is very helpful, particularly if the child has a developmental disability. You should be involved with your county DD board. That would be your very first place for you to go. If you think the child has a disability, but it's not a developmental disability, then I would certainly urge you to take your child, the child, to the pediatrician. Nevertheless, okay, if you believe that the child has a disability and the school district does this, a 30-minute observation and says they don't suspect it, You should do all the things that I listed. You should go ahead and get an advocate. You should file a complaint, whatever. But it is helpful if you have some tangible information that you can present. And again, it doesn't have to be from a physician. I mean, if your child is severely behavioral, for example, I mean, and the child isn't going to be able to go to a regular preschool. I mean, those kinds of things are going to trigger the need for the school district to conduct an evaluation. But I would certainly urge you to take your child, if you can find a developmental pediatrician, that's all the better. A neurologist, get a referral, because you're going to have more play if you have that in your hands at the point in time in which you go to the school district and demand an evaluation. I mean, one of the things that made the case relatively easy was because we had all this data, all this information about this child's functioning level, and the school district just didn't want to look at it. And so whatever information you can get is going to help you in your quest to have the school district evaluate your child.
And I think you may have touched on this next one, but I'll go ahead and read the question. How do you request an independent evaluation? Would this request go through the school district for them to pay for an outside evaluation at an outpatient clinic?
So the answer is yes, the school district, it would go through the school district. You should put the request in writing. All you need to say is that you disagree with the evaluation that was done by the school district. Now, there are times where the school district will find the child eligible, but you may agree with the fact that they found the child eligible, but not agree with anything else. And you can still request an independent if you agree that with the finding of eligibility, but not with anything else. And so for example, let's say your kid is having a reading issue and the school district hasn't done a communication evaluation. You can request an independent. Or you have a child with an orthopedic handicap and they haven't done an assistive technology evaluation. You can request that. And so yes, put it in writing, send it to the school district. And an independent, you guys, means independent. And I mean, I personally don't consider the ESCs to be independent. I do not allow my clients to use the ESCs as an independent educational evaluator. You also need to have an independent evaluator who has some expertise in the particular areas of your child's disability.
Next, we have, does the family have to initiate measures for filing a complaint or request mediation? Who incurs the cost of these legal services, the family or district?
So the family, anybody can request mediation. The school district can request it and the family can request it. The Ohio Department of Education has a pool of mediators that you can choose from. They are paid through the Department of Education, so that's not an expense that is borne by either side. If you want to have an attorney, then that would be your expense. And again, frequently we get our fees back. I will tell you that our law firm and other law firms do accept cases for people who can't pay us. I mean, if we think that you have a valid case, we will take the case whether you have any money or not. And we do that. In fact, all the hearings that I have ever had, and I have had many, and hearings are very expensive, are cases where I took the risk because my clients did not have the money to pay. I mean, the cost of going to a due process hearing is tens of thousands of dollars. Most families do not have the discretionary income to pay that for a due process hearing. So when we agree to go to a hearing, we take the risk that if we don't win, we're not going to get paid. And by the way, if you're asking who bears the cost on the other side, that would be you, because you're paying taxes in your school district that is paying for your school district's lawyer. Those lawyers are not being paid by the administrators in your school district.
The next question, what about the pushback of districts saying they are at capacity or they are already serving the number of children that the state has capped them at?
Are you kidding me? Are you kidding me? That's the response. Okay. That's not your problem. That's unfortunate. But if you are a resident in the district and your child is entitled to services and they are at capacity because their speech therapist has so many people, then they have to pay for somebody outside the school district to provide the service. That's the law. The answer isn't, I'm sorry, you don't get anything. That's the wrong answer. The fact that they don't have funding or they don't have enough staff, that's not your problem. Period. End of memo, end of tape.
Next, we have, if a family is planning to take the autism scholarship, are there pros and cons for the autism education plan?
So I'm not sure what that is asking me. I mean, the autism scholarship is determined. I mean, you have to have an agreed upon IEP with your school district in order to access the autism scholarship. The scholarship provider is responsible for the implementation of the services, and the school district has no further obligation to the parent to provide FAPE to that child. So I'm not really sure. I mean, are there pros and cons? There are pros and cons. And sometimes the providers are not able to provide all of the services that are necessary for the child for the amount of money that they're getting.
Next, we have, can you confirm the EI programs sending invitations to school districts to attend transition planning conferences to begin planning for transition is not counted as an official referral for an evaluation?
Sylvia?
That one is above my pay grade. I'm sorry. Yeah,
All right,
that would be.
So the referral is not the same thing. The referral is a direct request to the school district that you believe this is a child with a disability and that you believe that they need to be evaluated for services, for eligibility for services. And that has to be in writing. Again, it can be done by anybody who has information about the child. And so, no, I mean, the school district's knowledge of the child's potential need for services isn't a substitute for a referral. And I mean, if you're asking me whether, but as a practical matter, in most of those situations, the invitation to that transition meeting is going to be tough for them to argue that it wasn't a referral. So, I mean, a referral should be clear and concise and in writing, but generally speaking, most of the time when the EI providers are inviting them, they're going to say, this child is receiving early intervention services. We believe this child may need to have Part B services provided by age 3, and we're inviting you to this transition meeting so you can participate in the process. So as a practical matter, most of the time, I would say, yeah, that's going to serve.
And then thank you, Maggie Gons, for linking the specific rule change. She mentions that it made changes related in the category of developmental delay under the autism scholarship. A child may now be eligible for the autism scholarship under the disability category of developmental delay until the day before they turn 10 years old. And that is all the question and answers that we can cover today to be respectful of everyone's time. Thank you, Aimee and Sylvia. Very interesting topic. I think a very engaged chat shows that everyone was very interested in that. So thank you both so much. I will see you all back here in an hour. Actually, 12:30, 45 minutes for our next session on understanding intergenerational communication.